Hello friends, welcome to our podcast Legal Stories. Today we are going to talk about another important Supreme Court judgment, which came out just yesterday on the 25th of August 2025. The case is Criminal Appeal Nos. 3701 of 2025, in which the appellant is Ravindra Pratap Shahi and the respondents are State of Uttar Pradesh and others. I am your host, and today we will understand this case in simple English, as if we're talking at home, without taking any sides, completely neutral. Let's begin. Episode title: Delay in Justice, Waiting for a High Court Judgment and the Supreme Court's Stern Stand. Friends, first let's understand what this case was about. This is a story of judicial delay, where a criminal appeal was pending in the High Court for years. The appellant, Ravindra Pratap Shahi, is a de facto complainant, meaning he is the actual complainant. Respondent number 2 had filed a criminal appeal in the Allahabad High Court way back in 2008, appeal number 939 of 2008. The case was criminal in nature, but here the focus is not on the facts of the crime, rather on the delay in decision-making. Shahi filed 9 applications before the High Court requesting early listing and disposal, but nothing happened. Finally, on the 24th of December 2021, a division bench heard the arguments and reserved the judgment, but the judgment never came. After nearly a year, the Chief Justice had to intervene and assign the matter to another bench. Still, only interim orders were passed on the 28th of August 2024 and the 9th of January 2023, but no final hearing took place. Frustrated, Shahi approached the Supreme Court by filing an SLP, which was later converted into an appeal. Now, what evidence and discussions took place? The evidence was mostly documentary: High Court's orders, appeal history, Shahi's 9 applications, the reservation date, the 24th of December 2021, and the Registrar General's report, the 29th of January 2025. The report confirmed that after the judgment was reserved, no verdict was delivered within 6 months. As per administrative rules, such cases should then be listed before a regular bench. On the 9th of January 2023, no one appeared for the appellant, so it was adjourned. The Supreme Court focused sharply on the issue of delay. It said it was shocking that a judgment was pending for more than a year. The court referred to older cases like Anil Rai versus State of Bihar, 2001, where guidelines had been issued that judgments must be delivered expeditiously. The discussion also highlighted that many high courts still lack a mechanism where litigants can complain to the Chief Justice about such delays, leading to loss of public faith in the judicial system. The bench of Justice Prashant Kumar Mishra and Justice Sanjay Karol cited precedents like Jagdev Singh Talwandi, Zahira Habibullah Sheikh, and the recent Balaji Mupadi vs. Maharashtra case. So what was the conclusion? The Supreme Court disposed of the appeals but issued strict directions. It reiterated the Anil Rai guidelines and added further directions. Every High Court's Registrar General must submit a monthly list to the Chief Justice of cases where judgments have been reserved but not delivered. If a judgment is not delivered within 3 months, the Chief Justice must be informed. The Chief Justice will then issue notice to the concerned bench to deliver judgment within 2 weeks, failing which the case will be reassigned to another bench. This order must be circulated to all High Court Registrars General. Earlier, on the 15th of April 2025, the Supreme Court had already directed High Courts to decide such cases within 3 months, but this judgment makes the directions stricter. Now, what's the moral of the story? Friends, this case shows us that delay in justice is equal to denial of justice. The negligence of some judges can put the credibility of the entire judicial system at stake. To maintain public confidence, the system must be strict and transparent. What lessons can we learn from this decision? 1. If you are a litigant and your judgment has been reserved but delayed, you can apply before the High Court, after 3 months for early judgment, and after 6 months for transfer to another bench by the Chief Justice. Two, judicial reforms are needed, especially a mechanism for easy complaints against delay. Three, judges and officers must be accountable because delay shakes the faith of the common man. 4. Old guidelines must be strictly followed, otherwise the Supreme Court will intervene. Finally, this judgment is a wake-up call for all high courts. Speedy justice is the foundation of the rule of law. Friends, if you like this episode, please like, share, and subscribe. We'll meet again in the next episode with another legal story. Thank you, and take care.